Welcome back. And for those of you who are just joining us this afternoon for the first time, it's a pleasure to have you here with us. To begin this afternoon, we are honored to have with us the Honorable Noel Francisco, United States Solicitor General, and the Honorable Thomas Hardiman, Judge for the United States Court of Appeals for the Third Circuit, for a discussion of the First Amendment in America's system of laws and government. This session will be moderated by Ken Gormley, President of Duquesne University. So join me in welcoming them to the stage. The Honorable Noel Francisco is the 48th Solicitor General of the United States. Prior to joining the Justice Department, he was a partner in the Washington, D.C. office of Jones Day, where he chaired the firm's government regulation practice. While at Jones Day, Solicitor General Francisco appeared several times before the United States Supreme Court. He has also argued numerous cases in the lower federal and state courts on a wide range of constitutional, civil, and criminal matters. From 2001 to 2003, General Francisco served in the Office of Counsel to the President as Associate Counsel to President George W. Bush. And from 2003 to 2005, he served as a Deputy Assistant Attorney General in the United States Department of Justice, Office of Legal Counsel. The Honorable Judge Thomas Hardiman served on the United States District Court for the Western District of Pennsylvania before being elevated to the United States Court of Appeals for the Third Circuit. Before taking the bench, he practiced law in Washington, D.C. and in Pittsburgh. In 2008, the Honorable Chief Justice John Roberts appointed Judge Hardiman to the Information Technology Committee of the Judicial Conference of the United States. He became chairman of that committee and continues to serve in that capacity. A member of the American Law Institute, Judge Hardiman teaches a seminar on advanced constitutional law at Duquesne University School of Law.
Thank you and welcome. Good afternoon. I hope you all had a good lunch and you all get an A+ for getting back on time, so I appreciate that. We've seen thus far how the words of the Constitution tell us what the First Amendment means in large part, but it's important to see too that the government, specifically the courts, have played a major role in shaping the meaning over the course of American history of the First Amendment, sometimes for better, some would say for worse. And let me just start by saying a word about our distinguished panelists. We have a bunch of students here. We have some college students in the back and high school students, and we really appreciate your being part of the program. But you all may not know exactly who these figures are, so I just want to tell you. Solicitor General Noel Francisco is a major figure in United States government. The Solicitor General is the government's #1 lawyer in the Supreme Court. It is an incredibly important position. And Judge Tom Hardiman on the U.S. Court of Appeals for the Third Circuit, there are only 13 courts of appeals in the whole country, and they sit one step below the U.S. Supreme Court, deciding some of the most important cases in our system of government. So it is a true honor to have both of you here with us. So we talked a little bit about the fact in some of the other panels, Judge Hardiman, that even shortly after the First Amendment was adopted, it was under attack in different ways. And we talked a little bit about the Alien and Sedition Act, but one of the most stark examples of that attack involved the prosecution of a writer named James Callender. So just tell us a word about that.
Yeah, Ken, I think that's a good wake up after lunch. The Callender, for those that know about him, was an infamous fellow in many ways, a Scottish immigrant to the United States, but his role in the sedition acts was he was one of the several journalists who were prosecuted. He had written a book called The Prospect Before Us, and in that book he said that the Adams administration, and I quote, was a continual tempest of malignant passions. And if that weren't good enough, Callender lobbed one directly at old President Adams, whom he labeled a, quote, repulsive pedant, a gross hypocrite, and an unprincipled oppressor. So take that for what it's worth.
What happened to him?
Well, he was imprisoned. So he went to jail for, as I recall, I think about 9 months under the Sedition Act. But there were there was a congressman named Matthew Lyon from Vermont, sitting congressman, who had written something in a Jeffersonian newspaper in Vermont. And he was thrown in jail for, I think, 6 months, and then released and went back to Congress. And there were a few other journalists that were imprisoned during what many regard as probably the low point in our government's treatment of the First Amendment.
And I think I've taught constitutional law most of my career, and students are often surprised to learn that the first major cases in the Supreme Court dealing with the First Amendment actually found the lack of free speech rights. Schenck versus the United States in 1919 during World War I. And we talked a little about that yesterday, but in the years after Schenck was decided and then gradually abandoned in the 50s and 60s by the Supreme Court, really the Supreme Court has become increasingly protective of First Amendment rights in our country. And both of these gentlemen have grappled with these issues, both as lawyers and as judges and as Solicitor General. So I want to talk about some of the cases you've been involved in. So let's start with Solicitor General Francisco. You're in a very unique position. Lincoln Kaplan talked about the Solicitor General as the 10th Justice. Others have called the Solicitor General the conscience of government, because the Supreme Court tends to listen very carefully to what the Solicitor General says. The Solicitor General is sort of protecting the institution of the court at the same time. And as you know, I wrote the biography of Archibald Cox, one of my professors, who was Solicitor General during the Kennedy administration. And he was able to shape some very important Supreme Court decisions. Bell v. Maryland, Griffin v. Maryland in 1964, two of the famous sit-in cases during the civil rights troubles. And he got the Supreme Court to uphold the sit-in demonstrations and protect their free speech under the narrowest possible grounds until the Civil Rights Act of '64 was passed. So, Mr. General, in your tenure since 2017, you've had some major cases already in the Supreme Court, and one of them was the Masterpiece Cake Shop case decided earlier this year. That was particularly controversial. So tell us about the case and why the Supreme Court ended up agreeing with your position.
Sure, and you know, a lot of people often refer to the Solicitor General as the 10th Justice, as you did. I can assure you of one thing. I have never heard a Supreme Court Justice refer to the Solicitor General as the 10th Justice. But thanks for having me here. This is a great conference. And to get to your question about the Masterpiece Cake Shop case, you may recall from reading about it in the news, it involved a Christian baker and a gay couple that wanted the Christian baker to make a custom wedding cake for their wedding celebration. And the Christian baker said, I can bake you a lot of different things, but I can't bake you a custom wedding cake because it conflicts with my religious beliefs. And it went all the way up to the Supreme Court to address, one, whether it violated his free speech rights to force him to make that cake, and secondly, whether it violated his right to freedom of religion to force him to make that cake. I actually think that this line of cases is one of the more important ones that we're going to see the federal courts confront in the years to come. Back when I started as a law clerk right after law school, Justice Scalia issued a dissenting opinion in a case called involving the Virginia Military Institute, whether the Constitution prohibited a single-sex military academy run by the state. The case is not particularly relevant to this, but what Justice Scalia said in his dissent was relevant. What he made clear was that the Constitution gives government, and particularly state governments, quite a lot of power. But the genius of the Constitution is that it creates a First Amendment that allows people to say and not say what they want to say and what they don't want to say in an effort to convince others that their position is right, other positions are wrong, and to convince others that the government ought to change its position. And the insight is that just because a particular view is the dominant view today doesn't necessarily make it the right view. And in a democratic society, we should have the ability to debate with one another over what the right answer is and try to convince our fellow citizens that we're right and they're wrong. Maybe we'll succeed, maybe we won't. The reason why I think cases like Masterpiece Cake Shop are so important is because it really is using the First Amendment to defend the right of dissent. The dominant view in our culture is very different than it was 15 years ago. But the Christian baker in Colorado, in my judgment, had a constitutional right not to accept that dominant view. And I think it offended First Amendment principles to essentially force him to accept that dominant view by participating in a religious ceremony that was deeply contrary to his religious beliefs.
And Judge Hardiman, your court has tackled some cases fairly controversial that have gained national attention. One of them involved teenage girls who were suspended from school for wearing little bracelets that said "I heart boobies" as part of a breast cancer awareness effort. You felt that speech was not protected in the school, but why so? And then why did you conclude in a different case that some fairly horrible speech, online speech, by a student in JS versus Snyder or versus Blue Mountain School District was protected? This was the new phenomenon of people expressing speech from off campus through computers, and you thought that was protected.
Yeah, I'm glad we can talk about JS because I was in the majority in that case. The first one I was in dissent. They're both interesting cases. They're both cases that went en banc, which means it went to the full Third Circuit. We have 14 active judges on our court. Most of our cases are heard in 3-judge panels, but the I Heart Boobies case initially was heard by a panel of myself, Judge Greenaway, and Judge Greenberg, and then the case was taken up by the full court. And perhaps unusual in that case and interesting is that the 3 of us that were on the panel were all in dissent eventually. And the holding in the case was that the students had a constitutional right to wear this bracelet, and those of us in the dissent wrote that they didn't because in a case called Frazier, the Supreme Court had said that lewd speech is something that can be regulated in public schools. Now, the reason why it would seem incongruous in the other case that I personally said that the student did have a right to publish on her MySpace page all of these really awful comments about her principal and her principal's wife, who also worked in the school district, was because that was not in school. That was speech that occurred outside school. So one of the things that our courts, the lower federal courts, and perhaps the Supreme Court will increasingly have to wrestle with is this schoolhouse gate problem. Where does the schoolhouse gate begin and where does it end? Because obviously public administrators, teachers, and principals have more latitude to regulate within the schoolhouse gate and not outside the school.
And some of it has to do with the disruptive effect it has on the school, doesn't it?
Well, yeah, if it's disruptive, then you're into the Tinker test, and I saw we're going to hear from Mary Beth Tinker, the plaintiff in that seminal case from the Vietnam War era. So if there is substantial risk of material disruption in the school can regulate it, but in neither of the two cases you asked me about were they Tinker cases. So the question in one was lewdness, and the question in the other was out of school versus in school.
But before we leave this topic, because I think it's on the cutting edge, do you foresee circumstances where speech outside the school with students writing, some kind of vile, whether it's musical lyrics or attacking the principal, in one case in Pennsylvania, threatening to kill or hurt teachers or principals, that it can cross a line even if they're nowhere near the school, if the purpose of it is to disrupt the high school or the grade school?
We will, I won't speak specifically about that because we will see some cases along those lines. Suffice it to say that there are categories of unprotected speech. True threats are not protected, fighting words are not protected. So that's sort of your first step in evaluating these cases, is to ask yourself, is this in fact protected speech, or is it outside the realm of protected speech?
Okay, and General Francisco, you mentioned in talking about the Masterpiece case that sometimes an individual's right to not engage in speech is protected by the First Amendment just as strongly. The famous case, the Barnett case in the 1940s, where young girls who were members of the Jehovah's Witness faith didn't want to say the Pledge of Allegiance, for instance, and couldn't be compelled to. But you argued the recent Janus case in the Supreme Court, in which the court, another controversial one, agreed that compelling certain non-union members in the public sector to contribute union dues violated their rights of both speech and association. We're talking about multiple pieces of the First Amendment. What was your argument there?
So basically, as you said, most people think of the First Amendment as it allows you to say whatever you want to say within some limits, but generally you can say what you want to say. But another important component of the First Amendment is it protects your right not to speak. The government can't make you say something that you don't want to say. And one of the seminal cases about that was the Barnett case, which held you couldn't force students to say the Pledge of Allegiance. And another one involved a couple in New Hampshire who didn't like New Hampshire's license plate. The motto said, "Live free or die," because they were pacifists. And so they put a piece of tape over that portion of the license plate, were prosecuted under state law, and the Supreme Court held that you couldn't force them to speak, to disseminate that governmental message. So that's essentially what the Janus case was about. The Janus case involved a state law that applied to government unions, public employee unions. And under the state law, if you were a public employee and you didn't want to be a member of the union, so you didn't join the union, you were still required to pay roughly 85 to 90% of the union dues that you would have to pay if you were a full-blown union member. And the question is, was that essentially compelled speech? Think about, could the government force me to pay money to the Democratic Party or somebody else to pay money to the Republican Party? Clearly no. So the question is forcing somebody who doesn't want to be a union to pay dues to the union sufficiently similar to that it runs afoul of your right not to speak or your right not to pay for somebody else's speech?
And it sounds so clear and easy now that you've explained it, but these are all tough cases. And Judge Hardiman, you just referred to the fact that not all speech is protected. Child pornography is not protected. Fighting words, just a verbal punch in the nose, as it's been called, don't get any First Amendment protection. But these are tough cases. So tell these folks about one that your court handled involving the graphic videos of animal fighting, the Stevens case, because that one was a troublesome one in many ways. It seems to be so distasteful, and yet ultimately the Supreme Court agreed that that was protected. How do you draw the lines here and determine what finally goes out of bounds?
Yeah, it's a great question, Ken, because sometimes the facts are very, very troubling, as they were in the JS case. I mean, this speech, the parent in me, the community member in me, wished I didn't have to say that she could say what she did, but she had a First Amendment right to do it. Similarly, in the Stevens case, these were graphic videos of dog fights that were published in Japan, most often. Japan pit bull fights were the names, as I recall, one of the videos. So they're published in Japan, where this is apparently legal, sent to Virginia, where Mr. Stevens was living, and then Mr. Stevens sells them in the United States, puts them into the stream of commerce. He gets prosecuted here in the Western District of Pennsylvania, is found guilty by a jury, and is sentenced to prison. Another case that went to a panel, and the panel said the conviction stands, he violated the law. We took it up en banc again. The full court heard it, and I believe by a 9-3 vote, the vote wasn't close. We held that Mr. Stevens' First Amendment rights were violated because the statute under which he was prosecuted was unconstitutionally overbroad. And that's something that's always an issue in First Amendment jurisprudence is the incursion or the restriction on speech narrowly tailored so as not to capture more speech than is necessary to protect the public. And the Supreme Court affirmed us with only one dissent. An interesting side note, the dissenter showed up at our judicial conference, Justice Samuel Alito, who is our circuit justice, and he began his speech about the Supreme Court by citing the Stevens case and lamenting that indeed, even sometimes the Supreme Court gets it wrong.
Let me ask both of you, we're looking at these nice displays of the pieces of the 45 words of the First Amendment, and it says Congress shall make no law respecting all these things or of the press. Okay, so it gets special mention in the Constitution. But who in God's name constitutes the press today? We have, smartphones, computers, bloggers, tweets, podcasts. So can everyone go to the White House press conference and just have a badge that says blogger on it and you get to go in? Who constitutes the press now?
I think it's virtually impossible to say who constitutes the press. And I don't know that I expect to see courts try to answer that question. The reason why the White House can restrict the number of people who come into the White House to the White House press conferences is because even amongst the press, they get to pick and choose who comes. There are just not enough seats for everybody else. To me, the important question in this era is what constitutes speech, because we now have such a multiplicity of avenues by which individuals can speak. And we now have platforms where any individual can have a voice that's nearly as loud as a traditional newspaper is. And so in that era, are we going to treat some kinds of speakers differently than others? I frankly suspect the answer is no. We have a lot more speech today, but that I think is just going to mean we have a lot more things that are protected by the First Amendment.
Judge Hardiman?
Yeah, it's a tough question, and I've enjoyed debating this with you over the years when you were professor and then dean and now president. It's hard. We have these categorical baskets that require us to interpret things. What is an establishment of religion? What is speech? What is the press? I tend to agree with the general that most of the action will be in not defining who are the press, but in defining what are the contours of protected speech. Maybe it's just because the horse is out of the barn, I don't know.
Okay, and we've heard a bunch of panels talking about technology and its impact here. And so the courts are going to have to tackle with these issues that the panelists were talking about in the national security realm and others this morning. So they're going to be talking about how computers and drones that can invade privacy and robots and everything else dovetail with the First Amendment guarantee. Interestingly, in the criminal procedure area, they've started to dip their toe into these areas of new technology, like the Jones case dealing with GPS tracking and whether you need a warrant to do that. The Carpenter case dealing with cell phone towers. Do those cases in the criminal sphere tell us anything about where the court is going to go in talking about new technology and the First Amendment?
I actually think the answer to that question is no, and that you may well see the court go in opposite directions in those two areas. So in the Fourth Amendment type cases, the Supreme Court just heard a case last term called Carpenter. And it had to do with whether the government needed a warrant if they went to your cell phone provider, Verizon, and had them give you the records that showed everywhere that you had carried your cell phone to over, a 2-3 month period. And if you looked at ordinary old Supreme Court doctrine, what it said was that if you were going to a third party, like a telephone company, and asking for those third-party records from the telephone company, you didn't need a warrant, because the person who was asserting the Fourth Amendment rights didn't have any right to prevent that third party from giving that information to the government. Now that case gets up to the Supreme Court, and if you just look at black letter law, it looks like a pretty easy case. But the big difference is that with modern technology, that means that the government can quite literally pinpoint your every movement over a 30, 40, 50-day period. And that is quite a big intrusion into privacy that you didn't have if you were simply going to the telephone company to find where you made landline telephone calls to. And so what the Supreme Court essentially said was, you know what, we're not going to apply that old doctrine to this new technology because it just is too big of an intrusion on individual privacy. I actually think in the First Amendment context, you're going to see the opposite. You're going to see the Supreme Court essentially applying existing doctrine to new technologies to make sure that new forms of speech are protected. Because I do think that at the end of the day, the First Amendment is meant to, no matter how often or how loudly you speak, it's meant to protect that right to speak and that right to criticize the government. And they're going to be very leery of government's attempt to restrict that speech just because it can find its way to the world in many different ways.
Judge Hardiman, does it provide clues for us?
Yeah, I think I agree with the general. I'm loath to disagree with the 10th Justice, but I think, I'm sure he's right, but I'm not quite as confident in this dichotomy between the Fourth and the First Amendment. But some evidence to support your point. I think Brown v. Entertainment Merchants comes to mind. A fascinating decision about California's attempt to regulate violent video games. Do violent video games cause actual violence? What does the social science say on that? Justice Scalia, in that case, likened the violent video games to the grim fairy tales, saying this is essentially different in degree, not different in kind. But I'm curious and really eager to see whether at some point the Supreme Court tells us that some forms of electronic communication aren't just different in degree, but perhaps could be different in kind. That might be a bridge too far for them to go. I don't know, but it'll be interesting to see.
So one of the speakers earlier today, or maybe it was yesterday, predicted that the new Supreme Court, with Justice Kavanaugh on it now, would start retrenching. We talked about how the trajectory since the 50s and 60s has been to broaden, strengthen First Amendment rights. But there was at least one panelist predicting that that would change with the new Supreme Court. So I'd ask each of you what you see with the court going forward in terms of protection of First Amendment rights. And this is where I'd like to, especially since we have so many students here, I'd like you to tackle, you can feel free to talk about specific justices, but I'd like you to tackle the underlying assumption a lot of times that justices are going to vote their party, in essence, that we have 5 R's and 4 D's, and somehow that is going to predetermine the outcome. So I think it's very important to talk about that issue and thinking about where we're going with the First Amendment.
Well, just to go back to the cases we talked about, you remember the boobies bracelet case, that was a 9-5 vote, and there was quite a difference between judges on both sides of that 9-5 appointed by Republican and Democrat presidents over decades. Even more starkly, in the JSV Blue Mountain School District, the vile off-campus speech by the middle schooler, that vote was 8-6, and in the majority were 5 Third Circuit judges appointed by Democrat presidents, 3 of us, including myself, appointed by Republican presidents, and in the dissent, 6 judges, 3 appointed by Democratic presidents and 3 appointed by Republican presidents. So speaking only for the circuit courts and for the district courts, because I don't know about the high court, I can tell you that the notion that what we do every day is politics by other means is completely false. It's not even close. It's all about the facts and the law and applying them, and doing so on our court in a collegial manner, because you're always doing it with 2 others or sometimes 13 others.
Okay.
I don't think you're going to see a major shift on the Supreme Court with Justice Kavanaugh coming in to replace Justice Kennedy for 2 reasons. First, Justice Kennedy was one of the most robust defenders of free speech principles on the court. And I think that Kavanaugh is going to be equally robust in defending free speech principles. I don't think there's a lot of daylight between the 2 of them on that issue. But secondly, I think it's because on a lot of free speech issues, there's not a lot of daylight between most of the justices. I think free speech, along with a couple of other areas, is one of those areas that tends to unite the justices across ideological lines. So that if you don't, maybe you don't always see lopsided 8-1 opinions or 9-0 opinions, but you often see, even in 5-4, 6-3 opinions, unexpected alliances. Some conservative justices joining with some liberal justices in both the majority and the dissent. So I don't think generally it's an area that divides them on ideological lines, and in many cases it brings large majorities
And let me
together.
ask you about that, because that's really important. I remember interviewing Chief Justice Berger years ago, and he told me he felt the most significant opinion he ever wrote was Miller v. California, having to do with, you know, the obscenity, the new obscenity test. But why is it, General Francisco, that you do see this? Because part of our conference is to talk about where we find common ground as a country at a time when it seems to be really difficult to identify that. Why is it that the justices on the court who are the most solidly conservative or Republican, most solidly Democrat or liberal, end up agreeing on this?
I think it's because over time, and it hasn't been an easy path and a straight path for the Supreme Court, but over time, both sides across the spectrum have been in dissent and not been in dissent, and they've realized that it is very important to, one, protect the ability of the minority to speak, no matter how odious we may think their speech is, no matter how much we disagree with it, we need to protect their right to speech. And 2, it's only when you protect somebody's right to speech, even to engage in the most uncivil speech, that you have the hope for resuscitating the idea of civil debate in this country. Because the worst thing you can do if you want to promote a civil debate is to suppress the voices of dissent. That is going to foster incivility far more than a free and open debate where we confront in a room like this people who have views that very much differ with our own.
Yeah, as you were talking, it made me remember, I think the first program I worked on when I came to Duquesne in 1994, we had Gerald Gunther here, one of the great constitutional and First Amendment scholars. And he came to my class, and people were talking about, at that time, hate speech in colleges, because there had been a bunch of universities, including his own Stanford University, that had tried to suppress speech that they determined to be hateful. And he shocked the class and me, because they thought he'd be on their side and saying this stuff has no place in a university or a college. And he said he grew up in Nazi Germany as a young boy, as a Jewish young boy in Nazi Germany, where he was in the schoolyard and people would spit at him and call him, I believe it was Judenso or something, but it meant Jewish pig. And despite that, when he came to the United States, he understood more importantly why it was that this had to be protected. And so he was a firm believer that you had to protect that speech, and as Governor Kasich said this morning in the opening video, overpower it with more and better speech. And I think what you're saying is the Supreme Court, and these are all the top-notch jurists in our country, no matter which president appointed them, understand that basic principle. So let's wrap up by talking about what you think the Supreme Court has contributed to the evolution of the First Amendment in our country. So you're the top lawyer for the U.S. government in the Supreme Court. You're, Judge Hardiman, sitting on one of the highest courts of the land. What has the Supreme Court done to help move forward in a positive way the evolution of the First Amendment in our country?
So I'm going to do what I occasionally do in oral arguments, often not with great success, but I'm going to resist the hypothetical a little bit. Because I actually don't think it's the Supreme Court that has done so much to contribute to free speech in our society, but the First Amendment. It's easy to take for granted now the principle underlying the First Amendment, at its core, that you have a right to criticize the government that has power over you. But at the time, that was a very revolutionary principle. At the time, you could be hanged, jailed for criticizing the government. So it was our founders that had the genius to create this right that allowed us to be harshly critical of our government and to have that speech be protected. What I think the Supreme Court has done is it has protected and nurtured that right over the years. But to me, it's the innovation of the founders that is so revolutionary.
I agree completely. I think it's hardwired in our the American mind. Freedom of the press, freedom of religion, freedom of speech. These are our first freedoms. These are things that we all cherish. Every non-lawyer cherishes these freedoms. So I agree that it's the court has certainly played a role. The court has done a lot from time to time to check excesses. Ironically, the court didn't have to check the excesses of the Sedition Act back in 1798 and 1800 because when Jefferson won and the Democrat Republicans took over from the Federalists, they just changed the law, sort of in the same way
Right.
the independent counsel law was scuttled after the episode that you wrote about, Ken.
Well, let me just say that when I had the privilege of serving as dean of Duquesne Law School, one of the things I was most proud of was our long tradition of producing young men and women who went on into public service, government service, because in my view, that's one of the greatest gifts you can give society with the talents that you have, and including as a lawyer. So I would like to thank these two gentlemen for their public service at the very highest levels and for a wonderful panel. Thank you very much.